And sir, you're Brandon Bell?
Yes, ma'am.
The best you can, raise your right hand, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay. And will he waive the formal reading of the motion?
So I.
Give me just a second to get back to that. Mr. Bell, in cause number 24, DCCR 1008, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation April 21st of 2025 for the second-degree felony offense of aggravated assault with a deadly weapon. That was a 5-year deferred probation. Is that correct?
Yes, ma'am.
The motion alleges that you violated your probation. Count 1 alleges that you failed to immediately report to the community supervision officer your contact information. And is that true or not true?
I failed to.
True or not?
It's just true or not true. You can explain later. So did you give them your contact information or not?
Yes, ma'am.
You did give it to them?
Yes, ma'am.
Okay, so that's not true. Count 2 alleges that you provided a urine sample May 29th of 2025 that tested positive for tetrahydrocannabinol. Is that true or not true?
Yes, ma'am.
True or not true?
True.
Count 3 alleges that you provided a urine sample July 17th of 2025 that tested positive for tetrahydrocannabinol. And is that true or not true?
True.
Count 4 alleges that you were at a location other than your residence at approximately 3:10 a.m. and 4:55 a.m. on July 10th of 2025 in violation of probation. Is that true or not true?
True.
Count 5 alleges that you failed to provide all records and documents required by the supervision officer within 30 days of their instruction. Is that true or not true?
Not true.
Count 6 alleges that you failed to provide verification of entering and successfully completing the BIP program, the Battering Intervention and Prevention Program. Is that true or not true? Have you done the BIP program?
No, ma'am.
So that would be true that you haven't successfully completed it, right? Okay. Count 7 alleges that you failed to, that you
I think I should say not in there, Judge, I'm sorry. You failed to not have any communication.
state wish to amend that to say not on number 7.
Yes, Judge.
Failed to not, any objection?
Objection.
So 7, hold on, let me make that. I'm printing it because it'll be easier for me. All right, so 7 says that you failed to not have all communication with the victim regarding your child through an approved third party by repeatedly appearing at the victim's house to, quote, see your children. Is that true or not true?
True.
Count 8 alleges that you admitted to the adulteration of your urine analysis on June 30th of 2025, and is that true or not true?
True.
You understand adulteration? If the court could explain adult, I don't think you.
I mean, did you show up to probation and do either a fake urine sample or have some type of, what was it,
He admitted to drinking something that made his urine negative.
gotcha. So did you do that?
No,
You didn't? You just admitted it, but you didn't really do it?
Did you say it, or did you say that, or not? That you admitted to drinking something?
So it says you admitted to the adulteration of your urine analysis, that which means you told your probation officer that you did something to make your urine analysis negative. Is that true or not true?
no, any piss test I
Urine
had.
test.
Any
Urine, listen.
urine test I failed with.
Listen to my question. I don't care about any of that.
Yes, ma'am.
Did you admit to your probation officer
Not
that you did you admit to your probation officer that you drank something or took something that would make your urine clean?
Not that I know of.
Okay.
Let's say not true.
Count 10, let's see. Actually, count 9. Hold on, I'm out of 5, 6, 7, 8. What I missed here? Count 9, so this goes over here, alleges that you had contact with the victim of the offense, either in person, by telephone, via mail, or through a third party several times after being put on probation in violation of your order. Is that true or not true?
You said it again?
Have you had contact with the victim of the offense?
True.
And then count 10 alleges you are behind in your court-assessed fees as of July 17th, 2025 in the amount of $337. And is that true or not true?
True.
Did you enter your pleas of true to counts 2, 3, 4, 6, 7, 9, and 10 freely and voluntarily?
Yes, ma'am.
And because those counts are actually true.
Yes, ma'am.
So we've got, I'm going to find those counts true. Ms. Lopez is here. What? Let me look back at something real quick.
David?
When was the last drug test?
My last drug tested him on the 18th of August.
And it was negative?
It was negative.
And has there been any follow-up or treatment with spinal top?
You mean mental health or
Mhm.
drug treatment? Mental health, yes.
Okay.
Yes.
Okay.
Weaver?
Oh wait, Your Honor, I apologize. August 18th was his last drug test and he tested positive for THC. He has since been drug tested again in September and it was negative. I gave you the wrong date there. I apologize.
And I think the concern, if Ms. Lopez can kind of go into a little bit more detail about our conversation, is that he may be using synthetic, which doesn't show on the tests at probation. And there's obviously an issue with the no contact, which is why I have the complainant here. I don't think either one of them are adhering to this.
So, last known contact that you know of that's not in here, has there been any?
I was called by the complainant on Thursday of last week and she admitted that they had been seeing each other that day. And she was angry but it's very inconsistent whether she wants to be around him or not.
Here we go. Brandon Bell is back in front of the judge, and judging by the tone, already this isn't just a routine. Hearing something tells me this probation review is about to go sideways.
Some days I get calls.
Well, but I told you.
You come back in front of you.
Just be quiet.
I told you can't have contact.
Yes, ma'am.
And you're the one that can go to jail.
Yes, ma'am.
Okay, based on all of these allegations, I realized that I reinstated a bond and we had a hearing, it looks like, where I ordered some spinal top, but it sounds like this is not going in a safe direction at this point for anyone. At this point, I'm going to find that it is in the best interest of our community, best interest of the victim, and based on all of the factors in 15.17 and the fact that you're on probation for an aggravated assault with a deadly weapon, I am going to make this, at this point, a no bond. You will go back with the bailiff. I'll reset your case for an updated pre-sentence report. We can have any other testimony at that time with regard to the other allegations that are still pending. If you have any witnesses, then...
Since she's here, do you want to elicit testimony from the victim or not? She is
Judge,
here.
but my preference would be, may she come up to be addressed by the court?
Yeah.
Ms. Bell?
All right, you're Jasmine Dempsey. And will your client waive the formal reading of the indictment?
Yes, ma'am.
Ms. Dempsey, in cause number 25 DCCR 0315, you're charged with a state jail felony offense of theft of service, and that's from December 11th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Parker? Do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you will be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 2-year deferred adjudicated probation. There would not be a fine, but there would be restitution ordered in the amount of $967. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? I have to ask everyone. State tenders number
No
one.
objection?
It's admitted. Is there any evidence that Ms. Dempsey is not
There
competent?
you are.
And since we have the restitution, is there any issues?
Yeah, we waive.
All right, so what I'm going to do, Ms. Dempsey, is waive the pre-sentence report. I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to defer all proceedings in accordance with your agreement, place you on probation for 2 years. You are ordered to pay is it $967?
Yes.
The $967 in restitution and follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you do not have a felony conviction on your record. And at the end of the probation period, the case will actually be dismissed if you successfully complete that probation. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, you could be found guilty, so you would be a convicted felon, and you would go to the state jail prison for anywhere between 6 months and up to 2 years. Do you understand? It's very important that you make monthly payments on that restitution amount. Some people think they're going to wait for some money to come in, or they're going to wait till the end of your probation. The quicker you get everything taken care of on your probation, you can even potentially get off early, okay? All right, have a seat in the courtroom. The lady that's at that desk right there, she's with probation. She's going to call you up when she's ready to go over your paperwork. Good morning. You are Mark Hebert?
Yes, ma'am.
And Mr. Hebert was previously in court, entered a plea of guilty to driving while intoxicated, third or more. I've received that pre-sentence report. Has everyone had an opportunity to review the
We have, Your
report?
Honor.
Are there any additions or corrections?
None more, Judge.
Not from the state, Judge, sorry.
Okay, that's right. And so, Mr. Hebert, I am going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, follow the agreement that you made with the district attorney and find you guilty of driving while intoxicated, third or more. Sentence you in accordance with your agreement to a term of 5 years in prison, but I'm going to probate that. You'll be on probation for 5 years.
Thank you.
You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation. In addition, you are ordered to serve your 10 days upfront time in the Jefferson County Jail. Are you working?
Just being temporary, yes, ma'am.
Okay, so you can either go do your 10 days if you're ready to go do those today. I will allow you to do weekends if you're working.
Okay, I thought I already did 10 days.
No, it doesn't, no.
It doesn't count.
We had
Yeah.
talked before about doing it on weekends. I'm not sure. Would you rather do it on weekends?
Yes, sir.
Okay, so what I am going to do is order that you serve those 10 days on weekends, starting this weekend, September the 19th. So you will be ordered to turn yourself in every Friday.
Listen closely when a judge starts listing counts like this. It's never a good sign. Each count represents a separate violation, and stacking them up can lead to serious consequences, even prison time.
At 6 o'clock to the Jefferson County Jail. You'll stay the weekend, they'll let you out, and you'll keep doing that each weekend until you serve that 10 days.
Okay.
It's very important that you're on time to the jail and that you also not show up obviously under the influence of anything, because that would obviously be a violation of your probation. So if you do everything you're supposed to while you are on this probation, this is an excellent opportunity because you will be able to serve that 5-year sentence while you're out on probation. The other side of that, however, is if you violate any condition of probation, you can be brought back into court and you'll be facing that 5-year sentence that you've already agreed to. Do you understand?
Yes, ma'am.
All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal.
Would the court, excuse me, consider either JCDI or drug catch? I don't know if the interlock
It's
is
probably,
necessarily
can I see that
appropriate. It was
back? I'm
in the-
sorry.
It
What's
was,
this?
No.
Oh,
it may
I'm
already be
sorry.
in the orders. My concern is it being a drug issue versus alcohol.
Yes, JCDI is in there. Okay, so part of the conditions of your probation will be that you enter and successfully complete the JCDI program. And so that is an outpatient treatment program. It is very important that you go to every meeting, you not test positive for anything. I think in addition, I don't know that I'm required to, the interlock's required by law unless I make a good finding otherwise.
I don't think it would hurt anything. I just wanted to bring that to the court's attention.
No, but I'm thinking I'd much rather probably a drug patch. That's probably going to be part of JCDI anyway, but it's going to be part of the probation for
If
sure.
there's any medication you're on prescribed by a doctor, you need to make sure you
Give that to
talk to
probation.
probation about that. Because he has some health issues.
Are you driving?
Yes, ma'am.
Do you currently have the auto ignition interlock device on your vehicle? Okay, talk to probation, that'll probably remain, at least for some amount of time. By law, that is required that you have that on your vehicle, okay? All right, you can have not yet. I also handed you a admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right? If you'll just have a seat here in the courtroom, probation will call you up when she's ready to go over your paperwork. When's the last time you smoked marijuana? Tell the truth. Because what's going to happen is I'm going to get amounts, the levels, right? So tell me the truth. When's the last time you smoked? That's the truth? Have you done anything else? Speak up. Promethazine? When's the last time you did that?
What is that?
Cough syrup. Anything else with that?
Judges, obviously, up to the court's discretion, but we're definitely going to reserve the right to dismiss the ISF, probably substance abuse track.
How old are you? 19? All right, so I guess what I would rather do, I want to go ahead and get the process going if he's got a plea agreement. But I think based on his age and the nature of the type of drugs he's using, I am going to raise that bond. We'll get the pre-sentence report done, see if there's any issues with regard to substance abuse, and if there's any upfront treatment that I find necessary at that point. So let's go ahead and go through the plea. And will he waive the formal reading? I know we started it, but we're going to go back.
Pled guilty. He said freely and voluntarily, and that's about where you left off.
All right, and so did you plead guilty to this offense because you actually did what they charged you with?
That's a huge red flag, even if his intentions were personal. Violating a no-contact order, especially involving a victim, is one of the fastest ways to land back in custody.
You didn't? You didn't do what they charged you with? Look at me and pay attention, all right? Okay? Everything's going to be okay, but you're young, and if you're going to be successful on any kind of probation in life, you're going to get some help early on right now so that you don't end up with a felony conviction, okay? But I need you to pay attention to my questions and listen very carefully and answer them. So, you're charged with burglary of a building. The question I asked is, did you plead guilty because you actually did that? Okay. I have here on the computer some documents that have your signature on them. Before you signed these, did you go over them with Mr. Parker? Do you fully understand them? Just pay attention to me right now. Do you understand the papers that you signed on the computer? And do you understand, if I follow the agreement that you made with the district attorney, that you will be waiving or giving up any right to appeal? So if I go along with this agreement, you can't change your mind later. Do you understand?
And there it is, no bond. That means Brandon isn't walking out today. The judge just pulled the plug on his freedom until the next hearing. This isn't a warning anymore. It's a consequence.
And it looks like the agreement's for a 4-year deferred probation, that there would be restitution ordered, which means you would have to pay back some money for any damage or whatever you stole, and they'll figure that out before sentencing. Is that your understanding? Do you also understand, if you're not...
Notice how the energy shifts here from revocation to redemption. Jasmine's case is the other side of the justice system, where accountability meets opportunity. But as we'll see, probation only works if you take it seriously.